Hi, I'm attorney Nick Alcock, and if you've been arrested and you have to go to Glendale Municipal Court, here's some tips about how to survive the process, things to consider, ideas to keep in mind. The one thing that I advise anybody who's charged with any crime is get information. The more information you can get about your case, the better off you're going to be. And that's beyond just, well, I had an uncle who was charged with something similar, because you never know if your case is comparable with your uncle's, whether or not you have prior convictions or your uncle does, who the prosecutor was, what the law was at the time. So I urge you to stay away from that type of information seeking. The internet's a scary place to go sometimes because there's a lot of conflicting information about really what happens. And there's conflicting information because the way the statutes are written, if you're charged with a misdemeanor, so you have to go to court in Glendale, you're charged with a misdemeanor. You're not charged with a felony. So a misdemeanor can be very serious. You can get up to 6 months in jail. So a lot of the information about the cases is going to be the statutory maximum, what the judge could give you on the very, very worst day. But that's typically not what happens to people. There's usually a number which is far, far less. So as you're gaining information and you're trying to learn more about your situation, you don't want to think about what the very worst case scenario is. You want to know that, as well as what do people typically get. And so if you have to go to court, the first thing that you do when you roll into court is the judge is going to ask how you plead. So you're going to have 30 days to think about it, 45 days to think about it from the date of arrest when the cop gives you a piece of paper with that summons on it. You roll into court. The judge is not going to be up on high waiting for you and the prosecutor waiting for you. It's not trial. It's just a time for you to enter a plea of guilty or not guilty. The vast majority of people, when they go to court, they enter a plea of not guilty. That can feel very strange, though, because if you are guilty and you're standing there in front of a judge, you're like, do I really want to say that I'm not guilty? It's procedural. It doesn't mean anything other than you want to see the evidence which is against you. You want to know more about your case. You want to talk and negotiate with the prosecutor. If you're facing jail time, they can assign a public defender to you as long as you qualify for their income requirements. So if you're a millionaire, you're not going to get a public defender. They have a way of figuring out whether or not you qualify if you're indigent. So if you're indigent and you don't have the resources to hire a private attorney, they will assign a public defender to you. Sometimes just automatically they'll assign a public defender to you as well, even if you don't necessarily meet the income requirements. However, if it's a case where the government and the city is not seeking jail time, they may not assign anybody at all. And then you find yourself in a kind of weird position that maybe you didn't anticipate, where you're standing in front of the judge by yourself, you're put in a room with the prosecutor by themselves. And so it's a weird feeling because you don't have representation there with you, and you're negotiating your case and you really don't know what your rights are. So the prosecutor might be asking you questions. Can you be honest with the prosecutor? Does that prosecutor work for you? No, they don't work for you. And if you don't feel comfortable talking about your case, you don't really have to. You can just say, hey, look, I don't want to talk about the facts of the case, but I do want to know what type of plea offer you're going to make. The advice I give people when they have to go to Glendale is you need to know when the plea expires. So many people come to us at the very tail end of the process. I don't blame them for doing that because you kind of want to find out, well, what am I really facing? And you're gaining information, and I get that. But say that you have gone to court, you've entered a plea of not guilty. You met with the prosecutor, you set it out another time, and then you set it out another time, and now this is your fourth or fifth court appearance. At that point, the judge and the prosecutor might say, hey, look, it's taking too long. So what's it going to be? You're going to enter a plea, or are you going to go to trial? So if you're hiring us kind of at the last minute, it makes it tricky for us because we have to do a very, very large amount of work within a very, very confined amount of time. So that's why we offer a free consultation. That's why we're here for you at the very beginning. We can advise you what we think will happen in that court and how much time you really have. On occasion, especially for shoplifting cases, nonviolent property offenses, there are times when a prosecutor may offer you a very, very favorable plea agreement, something which is effectively a diversion deal, where the case goes away after you do some classes, that type of thing. Every case is different, obviously, and I'm not saying that happens in every case, but on occasion as well, the plea is kind of a take it or leave it at that moment. Those are the questions that you have to ask before you walk out of court. If I walk out of court and I don't enter this plea agreement, is it going to be available for me at the next setting? The vast majority of the time, yes. However, there are times when people come to us well after the process and they think that plea agreement is still on the table, and it's not. It was a take it or leave it at that moment. So that's a question absolutely that you need to know. At some point you get to what I call the fork in the road moment, where it's trial or plea. And you can't have both. You can't go to trial and kind of see how it goes and at the very last minute change your plea. Technically that's possible, but that's not usually how it works. So the prosecutor will make a plea agreement for you at some point, and then you have to decide whether or not you're going to take it. You can enter a change of plea and be sentenced right there, or you can go to trial. When you go to trial, you're throwing yourself at the mercy of the judge or a jury, and you are potentially exposed to that maximum sentence. The question that you want to ask is, well, what do people usually get for this type of case in Glendale? What do judges usually get, that type of thing? That's information that you need to know. So my advice to you is that if you have to go to Glendale, the information that you want to get is, how much time do I have when it comes to this plea agreement? You want to be very guarded about giving information to the prosecutor, especially if you're thinking about hiring a private attorney. Ideally, if you want to hire a private attorney, we charge the same amount of money if we're coming in at the end or the beginning. We'd much rather work at the very beginning of the case, give us more opportunities to win your case. So I would say call us early, allow us to work through the process, and always understand whether or not you're giving up something forever. When you're walking out of court, have you lost your plea agreement? Is there no more time to file pretrial motions? Are you really going to trial? Is that your trial date? Is that a firm trial date? Is it very, very likely to go? These are things that the people, they hope against hope sometimes. They go to court and they keep getting court dates and they think that, oh, I'll just get another court date, kind of bury your head in the sand and that type of stuff. That's what winds up hurting people. People lose plea agreements. They lose the ability to negotiate. Most importantly, from our sake, when we're working on the case from the very beginning, I've been talking about pleas all this time, we want to research the case, work it up, and look for ways to win your case by filing pretrial motions. If you wait until the very, very end, then we may have lost the ability to file motions for bad stop, jurisdictional issues, foundational issues, all of the ways you can get a case dismissed before it goes to trial. If you wait until the very end, you may have lost your ability for anybody to file those motions on your behalf. So if you have a case in Glendale, 602-989-5000 is our number. That's 602-989-5000. We have free consultation. We've got an attorney here who used to be a prosecutor in that particular court in Glendale, and we certainly know all the prosecutors and judges there. We think it's a great place to represent clients. We appreciate working with the staff there, with the judges and the prosecutors, but just put yourself in a situation where you get information early and don't get behind that 8-ball at the very last minute and find out that you've compromised your case. That's a bad feeling. That's why we're here, and that's why our consultations are totally free. 602-989-5000. Thanks so much for watching. Really appreciate it.